The first case on the docket for Wednesday, December 15th, 2021, is Appeal Number 120464, State of Kansas versus Dominic O'Shea Holder, Reno County. Briefs both sides. We are ready to proceed, Your Honor.
Counsel, if you would please come to the lectern to enter your appearances and then return to counsel table.
Good morning, Madam Chief Justice and Your Honors. And for the third day in a row, I'm James Latta of the Appellate Defender's Office. And today I'll be representing Dominic Holder, and I'm ready for argument.
May it please the Court. Thomas R. Stanton, Reno County District Attorney representing the state of Kansas. I am present and ready for argument.
Both of you. Mr. Lattin. Left.
May it please the Court. James Latta of the Appellate Defender's Office representing Dominic Holder. May I please reserve 3 minutes for rebuttal?
3 minutes is reserved. Thank you.
Thank you, Your Honor. So today I'm here representing Dominic Holder. He was convicted in Reno County of distribution of marijuana and conspiracy to distribute marijuana. We appealed that conviction, and the issues that this court granted petition on, we argued to the Court of Appeals that the statute issuing the rebuttable presumption is unconstitutional. Now, in Mr. Holder's case, they gave an instruction that stemmed from the statute. However, and I don't know if we've ever seen anything like this before, I certainly haven't in my research, the instruction given does not mirror the statute. And for that reason, the Court of Appeals, before getting to the merits of my argument that the rebuttable presumption is per se unconstitutional, found that Mr. Holder does not have standing to attack the statute.
Sorry, but let's just start right there. How is your client harmed by an instruction that provides for a permissive presumption simply because the statute would have required a rebuttable presumption and would have been, I guess, harder on him?
Harmed because the instruction should not have been given at all. An unconstitutional statute, so the court used an unconstitutional statute to give what was likely a constitutional instruction, but that's not the court's job. The court shouldn't have given the instruction at all. We shouldn't fix the instructions to make them constitutional. There's no law that says that a permissive instruction may be given. There's no common law. That comes straight from the statute, and the statute says you may only give a rebuttable presumption. We can't have the Pitt Committee going in and fixing what the legislature has done and then saying that we can't challenge the statute. I mean, to me, the Pitt Committee is insulating unconstitutional statutes, and then we can't even attack them, and we'll keep giving these erroneous instructions based on no law. It doesn't reflect any accurate law. And
But your client didn't have to prove anything more, actually had a lower burden. I mean, the states had the burden the whole time, but the presumption was a weaker presumption against your client than what the statute presumably would have been. I'm still having trouble finding out how you're harmed by an instruction that does less than what the statute would have required.
he's harmed because the permissive instruction, there's no basis for it. It shouldn't be given at all.
In other words, there should not be any presumption that operates.
Exactly. So the jury still got a permissive instruction in front of them that allowed them to assume intent when it shouldn't have been given at all. And the basis for that instruction was an unconstitutional statute. And I just don't see how two errors can make a right. The statute is per se unconstitutional because it's a rebuttable presumption per the United States Supreme Court. And then we have the Pitt Committee come in and alter what the statute says. That to me is another error. The Pitt Committee is only supposed to tell you what the law is. They shouldn't be going in and fixing unconstitutional statutes to make them constitutional, and then when we appeal, say we can't challenge the statute.
Let's walk down that road for a minute. Why do you say that this rebuttable presumption in the statute is unconstitutional? That's not the Allen case from the U.S. Supreme Court is really the guiding light here, and it pretty clearly does not make the statute unconstitutional.
I don't think they were challenging the statute in the Allen case, and you couldn't challenge the statute in the Allen case because it was a permissive presumption. Here we have a rebuttable presumption, which no permissive presumptions can be challenged like that.
There's different kinds of presumptions, though, and what the Allen case dealt with was a mandatory presumption. If this happened, you must believe this. The rebuttable presumption in the statute says if this happens, then there's a rebuttable presumption, and the instruction that was given said if this happened, you may infer X, Y, and Z. This is not a mandatory presumption in this statute, right?
Sure, and I think mine and yours disagreement comes from reading of the Allen case. In my view, the statute that gave rise to the presumption was unclear. The court did not know what kind of presumption it was. So that's why they looked to the instruction to see what kind of presumption. It just, the statute in the Allen case just said there is a presumption. And nobody knew what kind of presumption that was. So the U.S. Court of Appeals looked to the instruction and said, well, because we don't know what the statute is, we're going to assume it's permissive because that's how they instructed. Here we have no worries about that. It says rebuttable presumption in the statute. That's why I think the Allen case isn't even on point. That's why they looked to the instruction first, is because they didn't know what the statute was, and the courts have been misreading that case. If the statute in that case had said there is a rebuttable presumption, I don't see how then you can go ahead and give a permissive instruction based on that, but because it was ambiguous, that's how they reviewed the instructions first. But I don't think that case stands for every time there's a presumption, we only look to the instruction.
So if I read Allen to say that you look to the instruction to see whether the defendant was harmed by whatever happened, regardless of what's in the statute, you look to the instruction to see whether the defendant is harmed, you say that's a misreading of Allen.
Yeah, so not necessarily. So for the first step, when we say, I want the statute to be unconstitutional, and I think we should be allowed to challenge it. So I don't think this instruction should stop us from doing it. So the first step would be we find the statute, we find error, we find the statute unconstitutional because it says rebuttable presumption. And then the Allen case is where we come in and where we do have some trouble where they gave the permissive instruction, and that would go more towards the harm caused, whether we have reversible error or not in this case.
And I'm still circling back to how is the defendant harmed by the statute when you agree that the instruction that was given doesn't match the statute?
Because there shouldn't have been an instruction at all. They shouldn't have even been allowed to have
I think that's a different question, Counselor. You want to attack the statute as being unconstitutional. And I'm saying, how does he have standing to attack a statute when the instruction doesn't match the statute?
Because the courts, the Pitt Committee, everybody used the statute as the reason for giving the incorrect instruction. That is the basis for the incorrect instruction. I don't see how we can say that because they corrected the error, now we're blocked from challenging the statute. That to me is just...
Jumping off a little bit from what Justice Biles says, isn't this come down to really a separation of powers? Because, we as the judiciary are responsible for looking at, errors, and you're not really saying that, I mean, you are because you're saying the statute's unconstitutional, but you're not really challenging the permissive instruction that was in the instruction. But why isn't the better remedy here, or actually the correct remedy, to go to the legislature and say, this is unconstitutional? Why don't you change this? How does the court get there? Again, to the standing, how does the court get to the statute?
Well, I would say that, so because the statute gave rise to the instruction, that's the error. I mean, if we...
Okay, so
we're
let's
just gonna
pretend for
allow-
a minute that there is no statute. Would you say that the instruction was still error?
Yes, because there's no basis in law to say that you have a permissive instruction that when someone has 450 grams of marijuana that you can presume intent. That would just be coming out of thin air. Where we would get the basis for that? I mean, you could just come up with any presumption and just say, because it's permissive, we can give it. You could presume that they're guilty because they're the defendant, because we just made that up. Yeah, there has to be some basis in the law for it. We can't just,
So if the instruction's erroneous, if we were to agree with you on that, what then? What happens in this case?
so if you find we can't challenge the statute.
Oh, no, I didn't go there necessarily. I'm just saying, start with, for purposes of the question, assuming that that instruction was error, which is your argument.
Right.
So what happens? Does that mean that we should remand for a new trial, at which point you raise your constitutional claim there?
So if the instruction shouldn't have been given and you find reversible error,
Correct.
sure, yeah, then we would, if we had a new trial, we'd raise it again. And if you're finding error now, we would ask for obviously a new trial without that instruction being given at all.
And if a court, any court were to say, yeah, we think that that presumption in the statute is unconstitutional, we're going to sever that and proceed, would you have a problem with that? It just strikes me that that's ipso facto what has happened here, is that, I mean, as you put it, the PIC committee, I mean, I think your words were something to the effect of the PIC committee is, you know, insulating these statutes, is fixing them. Does that ring true to you?
Yeah, that if we went back, then we would just start over? Is
Well, that what has happened is sort of a severance, an ipso facto severance.
I suppose, but there's still no basis in the law for the permissive instruction. So, the we have many cases at the Court of Appeals where they have held that this rebuttable presumption is in fact a permissive.
What if in this case, the court had given no instruction whatsoever on a presumption?
They'd
Would
give
you
it-
still be able to challenge the statute?
No, we would not, because then it would not have affected us. But the error comes from, and is that they're using the statute as a basis for the instruction. And just because they're changing the words, I mean, we'll never be able to challenge the statute. The statute will just be there forever.
Well, that was the source of my confusion. It sounded to me like, based on our last little exchange there, from your point of view, it's not necessary for us to find the statute unconstitutional in order for you to prevail.
I would agree with that.
But the way you framed your argument is, hey, we want to challenge the statute. But it's, I think, well, I don't want to put words in your mouth, but there's a tension between we want to challenge the statute and we want a reversal of our conviction. Do you see that?
Well, I want to be clear, we want a reverse of our conviction. I'm representing Mr. Holder. I just thought, I was hoping we could get a better standard of reversibility. If we found an unconstitutional statute, we could possibly get constitutional harmless error. Because, and I know that's a tough argument, but what's happening is we have an unconstitutional statute. Then we're changing the instruction in no law, but we're using the statute as the basis. And then we're allowing, on no law, we're letting two wrongs be a right, to make a lower.
Is the mechanism to challenge the law via the jury instruction, or shouldn't it? You knew what your client was charged with. You understood the implications of possessing a certain amount would equate, or not equate, but they would create a presumption of intent. What prevented you from challenging it earlier in the process? Isn't that the way you would challenge the constitutionality? My client is being charged with something that is unconstitutional on its, both as applied and on its face.
Sure, that could have happened, but obviously
You didn't, but wouldn't that be a means to do it in a more typical fashion, rather than using the jury instruction as the vehicle to challenge the constitutionality? And that's what you're doing here.
I agree. But I still don't see, I mean, they're never going to give it, they're always going to give their permissive instruction. So if we always say that insulates the legislature, I still don't see, even at trial court, how we get to the statute.
But what's wrong with the permissive instruction that was given here? I mean, juries are allowed to infer from the evidence elements of the crime. And, you know, the police seized, 44 pounds of marijuana. And you had the testimony of the woman Holler, I guess. I mean, her name's so close to the defendant, I hate to use it. But anyway, we have the testimony of the woman who's the other driver. We have the text messages between the two, and we have the officer's testimony about the cars being very close together. I mean, there's enough evidence here for the jury to infer that these two are working together in transporting, 40-odd pounds of marijuana. And it's not a big jump to think that 40 pounds of marijuana is not personal use, so they must be trying to distribute or possessing with intent to distribute. That's a perfectly reasonable way for the jury to read this evidence, right? So I get back to my question. And all that instruction said is, you're permitted to infer, but you don't have to. And remember, the burden of proof is always with the state. That's what that instruction says as a bottom line. How does that hurt? How is your client prejudiced by that?
So once again, he's prejudiced because it shouldn't have been given at all. And the reason is who sets the limit?
But can you say that the conviction would not have occurred but for that instruction?
That's our argument on harmless error.
I'm sorry?
Yes, that's my argument is it wouldn't, if the instruction hadn't been given, the conviction wouldn't have occurred.
Well, make it then. I mean, just take that instruction out, and with this evidence, explain to us why the jury would not have convicted this guy.
Because Ms. Haller was caught with everything. Mr. Holder had nothing. She was an accomplice witness. She wanted to get out of trouble. She was the first one caught. It's her word against Dominic's. And we're saying that Dominic was not involved based on the evidence in this case. And if that instruction wouldn't have been given, that Mr. Holder would have been acquitted.
So what you're saying is that without the instruction, with all the other instructions, a jury can still make an inference from 40 pounds of marijuana that there was an intent to distribute.
Absolutely. They're free to do whatever they want. What I don't want is the courts telling them a certain amount without the legislature setting that in the law. I mean, if we can give instructions that say at this weight, without it coming from a statute, that say at this weight you can infer this, what's to stop us from making it lower, to some point where it's so low where personal use starts getting blurry, whether it's really personal use or distribution. I mean, I just think that has to come from the legislature. There's no common law, there's no case law, there's nowhere to find that presumption. But juries...
Well, it's also an individual choice of each juror whether to infer that there's an intent to distribute from the amount of marijuana that is
right
captured.
And that's how I would like to leave it. Let the jury infer, let them use what they think is a good amount. I don't want the courts telling them where we cross that line. I mean, I think there's a difference between the courts giving an instruction and saying at this point you can find intent and between the jurors coming up with it on their own. I mean, if the court says that this limit, you get over this, the jury's going to say, well, they know, so we got intent.
Would you agree, though, that if the statute was the exact same, but instead of shall, said may, then that would be constitutional, even though it's still the 3.5? I
do not. And the reason is because we still have the permissible, we still have the phrase rebuttable presumption. The definition of a rebuttable presumption is you must presume the element unless the defendant does something. Changing it to a may almost makes it seem like the court could choose in what cases they wanted to give it in. And the shall, to me, just says you have to give it in every case.
But counsel, your constitutional challenge, doesn't that demonstrate a reason when you're doing a statutory construction why perhaps the jury instruction here is the correct interpretation of the statute in order to construe it in a way that is constitutional?
Because there is no way to reasonably construe the statute as constitutional. You would have to read out the word they want a rebuttable presumption. And I don't think we can fix it by saying, well, we're going to actually find that to be a permissive instruction. Because the legislature, we don't even know the legislature wanted a permissive instruction. They said rebuttable, and that's what we're going off of. Thank you, Your Honor.
May it please the court, Thomas R. Stanton. Two things that this court needs to realize. First of all, and it's in my brief, the defense in this case filed a motion regarding the constitutionality. They just never pursued it. The state filed a response citing all the current case law, and it was never pursued by the defense.
And you're saying that happened in trial court, Mr. Stanton?
Yes, Your Honor.
Yeah, that was my question, I guess, is
Yes,
what's
it
the
happened.
proper procedure here to challenge, it seems to me it's, using the vehicle as the jury instruction is typically not the way it's done. So when was that, when did that happen?
If I can just check my notes here just a second, Judge, I'll look at the,
And while you're checking, I'll add a question.
Okay.
By not pursued, do you mean that the court did not rule on the motion?
that is true, and he never, and the defense never asked for a hearing or never set it for hearing.
Does a defendant have to do that once the defendant files a motion?
I believe it's the court's responsibility to hear the motions, but I think when you get to trial and your motion hasn't been heard, then at some point you have to say, Judge, I filed a motion.
Right.
And if you don't, then you're waiving it. If you look at volume 1, page 85 of the record, you'll see the state's response to the motion. So I believe, I didn't see the motion added to the appellate record, but I can certainly go back and do that if the court wants to do that. But my response is in the record.
And what stage in the proceeding was that, Mr. Stanton?
That was prior to trial.
Prior to trial, upon the filing of the case, they challenged the constitutionality?
Yes.
Okay, thank you.
The other thing is that there is absolutely no way the defendant would not have been found guilty if this instruction had not been given. There was not even a lesser included given because there was no evidence that this was for possession with intent to use. So if you look at all the instructions together, there was no lesser included. The reason there was no lesser included is because the defense in this case, the strategy was to blame Alyssa Holler. And you heard it again today. It was all Miss Holler. It was all Miss Holler. So it was not a defense strategy to ask, to even seek, to ask a jury to reasonably find that 44 pounds of marijuana was for personal use, which is the only alternative. And so there's absolutely no prejudice to the defendant in this case. Instruction 8 is the instruction we're looking at, and it had all of the elements, all of the definitions, and this presumption in one instruction. So it was all in one instruction. And to be clear, the parties have to submit their jury instructions prior to trial, because I never know what the defense is going to be, and I don't know what might be argued during closing argument. And so that's why the instruction was given. First of all, the counsel starts here with a basic premise that all rebuttable presumptions are unconstitutional. And he bases that on his interpretation of Francis versus Franklin. But that's really not what it says. In Allen, both in Francis and in Allen, the courts were looking at the application of the jury instruction to the law. So the question becomes, what does the jury see? The jury, the statute, and the instruction work together to inform the jury as to what they must find. And so in this case, the jury was given the instruction, the PIC instruction, and it was not a mandatory presumption. It was not a mandatory presumption.
Doesn't Franklin say that a rebuttable presumption is unconstitutional?
My reading of it was that, Your Honor, that, let me go back and look at my quote. My reading was that it was not. And maybe I read it incorrectly if the court's suggesting that. But in
Well, I think it's that irrebuttable or conclusive.
Right,
Or a
'cause-
mandatory rebuttable.
Right,
But
'cause
but the court declined to decide whether or not a mandatory presumption that shifts only the burden of production to the defendant is consistent with the due process clause. So let's talk about that for a minute. Let's clarify what we're talking about with the burden, so a rebuttable presumption. If, certain facts are there, then you may infer this. And then what exactly is the burden that transfers to the defendant at that point? The burden of production, even though the burden of persuasion stays with the state? So does it shift the burden of production to the defendant at that point?
I don't think it does, because if you look at the Francis versus Franklin, their quote was, "A mandatory presumption instructs the jury that it must infer the presumed fact if the state proves certain predicate facts. A permissive inference suggests to the jury a possible conclusion to be drawn if the state proves the predicate facts, but does not require the jury to draw that conclusion." So it says a presumptive inference does not relieve the state of its burden of persuasion because it requires the state to convince the jury that the suggested conclusion should be inferred based on the predicate facts
Well,
proved.
the phrase says rebuttable presumption.
Right.
So implicit within that is that the defendant can rebut it.
Can rebut it, but isn't required to rebut it.
Well, if you're not required to rebut it, then the defendant automatically loses, right, based on that inference. We'll just say that. So what exactly is the defendant's burden at that point when it, to be able to challenge the inference? They have to produce something, right?
I don't believe it says that they have to produce something. I think it says that it is.
They may.
They may present something. But I think but the issue in this case is more along the line of, are we going to follow the law that has been established in this state and across this country forever, that in order to challenge the constitutionality of a statute, there has to be some harm. There's no harm in this case.
So your position is not to even deal with this issue, but just to go straight to the fact that, as you said, there is no way this guy wouldn't have been convicted, even if the instruction hadn't been given at all.
And I'll just give you, I think it'd been a really much closer case if the court had reviewed Jimenez. In Jimenez, he had 680 grams of marijuana, which is nowhere near 44 pounds. And so, and he made the argument, his defense at trial was, this is for personal use. So I think under those circumstances, it would be a much closer case. But that's not what we have here. And the law has always been, there has to be harm for there to be a constitutional violation. And there absolutely is no harm here. Absolutely is no harm.
And you would just prefer just to boot it on that and not reach the underlying issue that the appellant brings up?
Well, Your Honor, it's not my preference. It's what the law is. At some point, it needs to be dealt with, and maybe based on some of these cases, the legislature will deal with this.
Well, I think we're conflating the question of standing with the question of harmless error, aren't we? Or maybe I am, just in my mind.
Well,
Because I'm confused. Are you arguing no prejudice as a way of suggesting that there's no standing to make the challenge, or are you arguing harmless error, basically? Harmless error means that there's error, but it's just harmless because the jury it did not impact the verdict.
I'm arguing that I'm arguing that there was no error, first of all.
Well,
And
let me throw a marker there that I want to go back to, but finish the answer. I'm sorry.
there's no error, because the way that this was presented to the jury, it was clearly a permissive. They were given the opportunity to determine whether or not to apply the standard or not. And when they received that instruction, they had the opportunity to either accept it or not accept it. But even if it was error, the defendant can't get here because he was not harmed. That's my argument.
You say there was no error. What was the legal basis for this instruction?
The statute.
But it doesn't reflect the statute. So what is the basis for the instruction?
Well, I think it does reflect the statute. I don't think it requires legislative action to come up with a jury instruction. I think that the jury instruction was accurately depicted what the intent of the statute was.
You think that it reflects a reasonable construction of the statute?
I do.
Even though it changes the words?
Well, it interprets the words.
Well, you would agree that a rebuttable presumption is different than a permissive instruction, or a permissive presumption, right?
Only if all rebuttable presumptions are unconstitutional. I mean, there are presumptions throughout the.
Take unconstitutional out. I'm just saying, in the grant, the Allen case makes pretty clear there's a continuum of presumptions.
Correct.
You know, on one side, you got mandatory presumptions.
Right.
And that's, one thing. The other side, you've got permissive, and then somewhere in between, I think, you've got permissive presumptions. And a permissive presumption is a different animal than a rebuttable presumption, right?
The rebuttable, I will acknowledge to the court that rebuttable presumption does suggest that the defendant can come into court and rebut that presumption, which then, if all rebuttable presumptions are unconstitutional.
I don't care about the constitutionality. I'm trying to match your instruction with the statute. And
I
the
apologize.
statute specifies a rebuttable presumption. You gave an instruction that was a permissive presumption. So I think the question that the chief and I are both asking is, how is this instruction you gave legally appropriate when it doesn't match the statute? Because, and all of that's premised on a rebuttable presumption being a different animal than a permissive presumption.
Well, my argument to that would be that the rebuttable presumption, that it fairly stated the law because it was based on PIC accurately, and it informed the jury that a rebuttable presumption of intent to distribute exists under the law if a person possesses 3.5 grams or more, and also informed the jury it could choose to reject the evidentiary presumption. It creates,
Counsel.
I believe it creates a permissive presumption and not a rebuttable, but I understand that what the court's asking is, what's the difference between a mandatory and a.
No, I'm asking the difference between a rebuttable presumption and a permissive instruction, because the statute says rebuttable presumption. That's all I'm getting at here. And I think the statute says one thing, requires one, or, deals with one subject. The instruction dealt with a different subject, is what I'm asking about.
I mean, the
And to ask this-
difference is, I mean, the statute says there shall be a rebuttable
Rebuttable
presumption.
presumption, and it
So
does, it
so
does
that
not.
tells the jury they have to start there, and then they can take away from that, as opposed to the permissive that says you can get to that presumption, you may infer it. And that's the difference.
I understand the connotations of rebuttable
Right.
versus permissive, I do.
And-
And I
and-
think
but-
there is a difference.
And so this instruction does not reflect that starting point. It directs the jury to a different starting point than what the statute says. So how can that be legally appropriate?
Another way to ask the same line of questions is, what is the definition? What is the construction of rebuttable presumption? Is it ambiguous, or does it have plain meaning? And if so, what is it? And then we can, once we know your construction, then we can test it against the, once we know your construction, we can test that against the instruction that was given.
Rebuttable has a fairly clear meaning, Your Honor. And it suggests to the reader that something can be done to rebut the presumption. And I think that there may be some disconnect between the statute and the instruction.
What is that something that can be done? Is
If
it
you-
merely producing evidence, or is it
And that's
persuading the
it's-
jury?
I don't think it requires, the question is, does it require the defendant to put on evidence? Does it shift the burden if you say rebuttable? And does it require him to actually put on evidence? Or can it be done through argument alone, based on the facts? My interpretation, it can be done on argument alone. It does not require him to present evidence in order to rebut it.
If I could go back to what I think was Justice Lukert's question, because it's my question as well, and get an answer from you. And forgive me, Chief, you can rephrase this, but as I understood the question, it was, if the statute does not provide a legal basis for the instruction, how is the instruction legally appropriate? Is there any other basis other than the statute which would render?
No, the court can't just give an instruction. I agree, can't just give a willy-nilly instruction. The instruction is based on the statute.
So, for example, to take this completely out of the context of this case, just because we have case law that says strangulation might be sufficient for a jury to find premeditation, you wouldn't be saying, you wouldn't argue for a judge in a premeditated murder case to give an instruction that says, if you find that the defendant strangled the victim, you may infer premeditation.
Correct. That
would be an erroneous instruction.
I would agree it would be.
Thank you, Mr. Stanton. Latta, you reserve 3 minutes.
Thank you, Your Honor. I feel like in all candor to this court, I just need to clarify that you'll find in my reply brief, I spoke to defense counsel in this case and the court reporter, and there was not a motion filed by the defendant before. There was not.
Okay.
And you'll find that in my reply brief. I corrected the record to the Court of Appeals. But getting to Justice Standridge and Justice Wall's questions, the rebuttal presumption does shift the burden of persuasion, at least, to the defendant, and that's all it takes to be unconstitutional. We're taking one of the hardest elements there is to prove, intent, and saying here, and see, the jury, they can read these instructions, get to that presumption and go, we don't even need to talk about intent. We got it right here. We know there's this much marijuana, and that's it. And so we're just asking this court to find that the statute's the only basis for this instruction. Because the statute gave rise to the instruction, we can get there, find it unconstitutional, use the constitutional harmless error standard, and reverse both of Mr. Holder's convictions, please. And if there's no other questions, that's all I have.
Thank you, Mr. Latta.
Thank you very much.
Thank you to both counsel for your arguments. We will take this appeal under advisement.